Well, still staying in Nigeria, the Nigerian government has filed an amended 7-count amended charge against the detained leader of the proscribed indigenous people of Biafra, that's IPOB, name of Nnamdi Kanu. Now, the amended charge, which was filed by the Office of the Attorney General of the Federation and Minister of Justice, borders on treasonable felony and Kanu's alleged involvement in acts of terrorism.
Now, Nnamdi Kanu's lawyer, Maxwell Okpara, while confirming the charges, noted that they are yet to be made public, as Nnamdi Kanu will be rearraigned before Justice Binta Iyako of a federal high court in Abuja on Thursday. One may ask, what are the likely charges he might be facing this time? Well, joining us this morning to make sense of the situation is constitutional lawyer and public affairs analyst, Barrister Chukwudi. Good morning, Barrister. Welcome to the program. Now, 7 new charges against Nnamdi Kanu. A lot of us saw this coming, but what do you make of this move?
What we generally make of this is that we know that the Attorney General, who is the Chief Prosecutor in this charge, and the Chief Law Officer, has right under the law to amend charges, even without giving excuses to that effect. The essence of amendment is to bring to bear the necessary content of the charges, the offense, and other ingredients which must be contained in any charge. The essence of which is that the charge will start de novo, meaning that it will be read to the defendant, who shall take a fresh plea upon the amendment. That is to say, there must be a refresh, or what we call a follow-up upon amendment, which must be that the content of the charge must be brought to the knowledge of the defendant and his lawyer. It's been quite interesting that indeed it has not been made public, but however, the lawyer must have been served and the defendant must have been put to the known, because the Constitution, particularly Section 32, says that any person who is charged with any criminal offense must be given the facilities, and the charges, all the offenses must be brought to his knowledge in order for him to prepare for his defenses. So, amendment of the charge does not in itself alter the necessary ingredients in it. Rather, it may be.
All right, Barrister Chukwudi, that this is one of the cases that a lot of Nigerians will be looking forward to ahead of Thursday when he's to appear in court. Well, Barrister Chukwudi, as a lawyer, and also as we await the charges to be made public, what are the likely charges we could be seeing come Thursday? We are hearing things about, treasonable felony and alleged acts of terrorism. What do you think we can expect in terms of the charges when they are made public?
Please, can you come again? I may be interrupted.
All right, Barrister Chukwudi. Yes, as we await the charges to be made public, what are the likely charges that we could be seeing come Thursday against Nnamdi Kanu?
You see, by our training, we are restricted from speculating. We do not want to dabble into the convoluted web of speculation. We know that what he was charged before was conspiracy, treason, and treasonable felony. We may be saying that indeed maybe the elements which were contained in the first charges were not sufficient, and indeed they are bringing it up now in order to reinforce the charge. So we are still expecting maybe the federal government or the prosecution has reviewed its own case and found out that it may not likely sustain the charges and the counts which were contained in the charges against Nnamdi Kanu. So, in order to make it efficacious, they now decided to bring a particular offense which may likely come conclusively against the offenses which they allege that he committed. What we are saying is not to make speculations on the content of it, but they will make it public. You cannot continue to scratch the surface when the content will still be made known to you. But we know what he was charged before. So we may be making an inference that indeed it may still contain that of the treason or treasonable felony. However, what we are saying is that fair hearing, as referred to in Constitution, particularly Section 36, should be granted to him so that he would have not only the knowledge of the offense, but also have facilities and time and facilities in order to make his proper defenses.
Right. Now, Barrister, I mean, let's look at the concerns that the Ohanaeze Ndigbo group are bringing to the table. Because this group now, they're calling on DSS to ensure that Nnamdi Kanu is brought to court on Thursday. Now, do you think there could be anything that will hinder Nnamdi Kanu from appearing in court come Thursday?
That will be a state of chaos, because it is much expected that whatever that will lead to or prevent bringing Nnamdi Kanu to the court must have been seriously averted, and the federal government should take note of that. You see, when a person is arrested, the law says he must, within the specified period of time, be brought to court. And when you are unable to produce him to court, the next thing you should do, as mandated under the Constitution, is to grant him bail unconditionally. Tell me what facilities, again, if I may ask, that could be a militating factor restraining him from coming to court or preventing him from coming to court. The call from Ohanaeze Ndigbo is timeless. The call from the entire Nigeria is timeless. You are saying we have this man in our custody. It is not that the man is still at large, or that the man is evading bail or have eloped from your custody, but the man is right there with you, and you are telling us, or you are speculating that there is likelihood that he will not be brought to court. That would be a total disappointment and an unfortunate situation against the handling authorities, which are the federal government, particularly the prosecuting authorities. So whatever that would militate or serve as a stumbling block from producing him to court to answer the charges against him, who is present, who is alive, who is available, that would look, the court to look at it as a calculated attempt in order to continue to detain him unlawfully. When a person who is charged with a criminal offense or intended to be charged for a criminal offense or suspected to have been committed an offense and is arrested and is in custody and is not produced in court, who is ready and available, then it means that again will be a condition which under our law will be for lack of diligent prosecution. And the court in that provision, which according to our ACJA, which provides that when a defendant or a suspect is in court or is ready to attend court and he is not produced, or the prosecution is not ready in order to continue with the prosecution, the prosecution court can grant him to release him unconditionally, or release him so that the state or the prosecuting counsel or the prosecuting authority will know that they have shown much intelligence in prosecuting him. So we will not continue to suggest to the federal government not to produce him, but to ensure that he is produced. It is part of the fair hearing. And the court grants fair hearing as a serious factor for a person who is being detained and who is due for court. So without his production, that will be a lack of diligence on the part of the prosecution. And the court shall do the needful by granting him bail unconditionally.
All right. Thank you very much, Barrister Chukwu, the constitutional lawyer and public affairs analyst. We are waiting to see if Nnamdi Kanu will be rearraigned in court come Thursday in the Federal High Court in Abuja. Amendment 7 count charge, well, they've got to produce the man himself, I have to say. But thanks once again, Barrister Chukwu, for coming on the program.
Thank you very much. The pleasure is mine, and we hope that the needful is done in order to calm the rising tension in the heart of the Southeast and all the entire members of Nigeria who love justice.